Okay. Good afternoon or good noon, ladies and gentlemen. Welcome. My name is Mary Vic, and I am a counselor here at AGI. For those who are joining us for the first time, here is a little background on us. Alzheimer Group is a charitable organization that supports families and individuals living with dementia. Our services include activities for people living with dementia, individual and family counseling, support groups for caregivers, and courses, workshops, and webinars such as this. Our educational initiatives are made possible by the generous support of the Lassner Learning Center and the Lindsay Memorial Foundation. Before we begin, please note that while the chat feature is unavailable, there is a Q&A space for you to ask or type your questions. You may type your questions at any time throughout the presentation, and we will address them at the end. Today, we are excited to welcome back Ms. Mandy Novak-Léonard to speak on the topic of homologation. Mandy is a professional social worker and president of Les Évaluations, Mandy Novak-Léonard, Inc. Having always been passionate about bettering the lives of others, Mandy started her career as a mental health worker in the community and continued it at the CLSC level. Since 2015, Mandy has been in private practice doing assessments for the homologation of mandates and helping families of seniors who are in conflict. So ladies and gentlemen, it is really my pleasure and my privilege to introduce Ms. Mandy Novak-Léonard, and the stage is yours, Mandy. Thank you.
Thank you so much for that very warm welcome. I appreciate it, and I always appreciate when I see an invitation from AGI in my inbox to come and present. So good afternoon, everyone. Perhaps you'll be watching this webinar online later on. So good morning and good evening as well, whatever situation or time of day you may find yourself in. So yes, my name is Mandy, and I'm a private social worker, and I've been in private practice since 2015. Now, my work generally focuses on assessments about capacity. And assessments about capacity related to either homologation of a mandate or the opening of a tutorship. But let's take this step by step, because I am a very, very big fan of bringing things down to basics. Because when we have the basics, then we could springboard into the more, I would say, more complicated topics around this particular issue. So I am going to go and share my screen, and please follow the slides, but I plan to give you some anecdotes that are not on the slides that you may be able to apply to your individual situation. Again, I am happy to answer questions, so please put your questions in the question bar, and we will tackle them the best that we can today. All right, so let's share. Let's share my screen. All right, and let's get it going. This is the most challenging part for me, the technology. All right, share, and that should be coming up right now. There we go.
Okay.
Can everyone see that?
What I'm seeing right now, Mandy, is who am I? Is that the okay?
Correct, exactly. So let's get that up here. I just want to get it up here so that you can see it. Who am I? All right. I do apologize for this little piece. I did practice this, and well, all right. Can you still see it now?
Actually, it didn't change anything. It has been, oh, there you go.
Okay.
You can share it again. Right now, I don't see anything. Yeah.
That's right. I'm starting right at the beginning. And here we go. All right. Can you see that now? Who am I?
It's coming.
Here we
It's
go.
there you go. Yeah. Do you want to
Yes,
do the slideshow as well?
yes, I'll do
Yeah.
the slides. Thank
Sorry,
you.
sorry. I'm like, okay.
So today's topic, we really want to look at when, why, and how do we homologate mandates. Now, it sounds like a very simple title, but there's actually a lot behind it. So let's go step by step. So the outline of the presentation, we're going to talk a little bit about who I am. Then we're going to explore incapacity, because incapacity is really the basis of homologation. So I want to look at the two very, very important basics when we talk about homologation, and that is incapacity and mandates. So I really want us to have a very clear definition of those two concepts before we start to jump into when do we homologate a mandate, why do we homologate a mandate, and how do we homologate a mandate. I want to make sure that we all have the same definitions and we're using the same language, because that means we all have the same comprehension of these particular concepts. So who am I? I'm Mandy Novak-Léonard. I'm a professional social worker, which means that I'm a member of the Order of Social Workers here in Quebec. Every time I do a presentation and I see the years, the dates, I feel older and older every year, but okay. I've been a member since August 2008. I graduated with a Bachelor of Social Work in 2004, and then went back and did my master's and finished that in 2012. And I've worked in the community, I've worked at CLSC, and I've worked in private practice. I'm also a native of Beaconsfield, so a lifetime West Islander, and I have quite a bit of involvement in the community. I am a board member at Villable Repair, and I'm also a director at the Lindsay Memorial Foundation. And for fun, I like to exercise, I like to cycle, I like to sweat it out at the gym, I love to read, and I really love spending time with my children. So I want everyone to take a deep breath. We're going to start with the first topic. What is incapacity? So incapacity means that someone's judgment and reasoning is no longer fully present. What we mean by judgment and reasoning, like what does that mean? At the core of it is that the person can no longer consider the impacts of their decisions. So I want to differentiate two types of judgment and reasoning. Maybe many of you have had the privilege of raising teenagers at some point in your life. And you know, teenagers, let's say a 15, 16-year-old boy or girl, we know their judgment and reasoning is not what it will one day be, but often they will consider the impacts of a decision they're going to make, briefly consider it for a couple of seconds, and then still do whatever the heck they want because they're teenagers. That's very different than somebody who is living with either dementia, who have had a stroke, or have traumatic brain injury. There comes a point where they can't consider those impacts. They can't realize or appreciate what they're about to decide will cause or what will happen as a result. We also say that the judgment and reasoning is flawed. Some people will say that. Other people will just say that it's no longer present. Now, incapacity is not something that happens in black and white, does not happen in a straight tunnel. And I think that's where a lot of caregivers and family members find it very murky to understand, does my loved one still have capacity or not? Let's talk a little bit more about this subject. Incapacity can happen for many reasons. It can be because someone's had severe mental illness or intellectual disability, a head trauma from a serious accident where there's damage to the brain, a stroke, and then as a neurocognitive disorder, a degenerative disease like Alzheimer's disease and other forms of dementia. Today, I mean, I could talk all day about capacity and incapacity and the need for homologation. But today I really want to focus on incapacity in the context of dementia, in the context of a neurocognitive disorder. So when we talk about a stroke, or we talk about someone who had a traumatic brain injury, this is somebody who had capacity up until the moment the event happened. So it's a very defined timeline. Before they had the car accident, they had capacity. The moment they had the car accident, their brain was impacted and their capacity changed. We know the exact moment that it happened. All right. With dementia or neurocognitive disorders, it's not black and white. It's much more nebulous than that. So with people with dementia, it's not a sudden event. It's not something that happens one moment to the next. And judgment and reasoning will often diminish with time. So we will see that they retain capacity for certain things, but not for other things. So as time progresses, we start to see more and more holes in their judgment and reasoning. So when we meet somebody with dementia, we cannot assume that they have impaired capacity or that they have an incapacity. A diagnosis itself does not mean the person is incapable. And in fact, when most people are first diagnosed, most, not all, especially in the early stages, it's at that point that the doctor will tell patients, please go and see your notary and get all your paperwork in order. Because we know that in the beginning, it's a diagnosis. We're not saying that there's the incapacity right away. So we always have to keep that in mind. Just because someone has a diagnosis doesn't mean that they are incapable simply because that diagnosis has been given. All right. Another thing that can make capacity with people or incapacity for people with dementia even more confusing and more murky is that capacity can actually fluctuate throughout the day. It can be dependent on many factors. If someone's more anxious or agitated, their capacity can be affected. The quality of their sleep the night before can have a big impact. And the time of day. So not only do we have to look at the inch when we're talking about capacity, and when I mean the inch, I mean the hours in the day and the mood and what they've experienced throughout the day, but we also have to look at the mile, the overarching functioning of the person. Now, often memory can be another confusing piece here, okay? So memory plays a part in incapacity, but poor memory recall should not be confused for incapacity. So someone who's forgetful at the beginning stages, someone who has maybe a bit of confusion, that we cannot say the person is incapable, that they have an incapacity. With time, as the judgment and reasoning continues to diminish and the severity of the memory comes in, well, yes, then it does. But overall, when we're homologating mandates, we're not homologating based on the person's memory recall. We are really looking at judgment and reasoning. And unfortunately, people who aren't as experienced in this field will confuse the two. And I'm talking about professionals when I say experience. So I'll give you a little tidbit into when poor memory recall can play a part in capacity. So as many of us know, when our loved one is living with dementia, there can be a disorientation to time, which means that they might not know what year it is, they might not know what month it is, they might not know what day of the week it is, or they might not know the actual date. Well, when it comes to managing their finances, if they're having a hard time managing, if they're disoriented to time, it can be very difficult to stay on top of their bills because the first of the month comes, but they don't realize it's the first of the month, and now there's bills that are overdue. So that's the beginning of an incapacity and how it might tie into poor memory recall. But when we remind them or we prompt them or we support them, they know it, how to pay the bill. They know the concept of bill payments. They certainly know that when they pay their bills, they have to make sure that they have enough in the bank to pay it. But so the judgment and reasoning is still there. It's just the memory that's poor at that point. It's the memory recall that's challenged. So again, we can't confuse the poor memory recall automatically with an incapacity. I'd like us to continue in this sphere. And I want to talk a little bit about what is a protection mandate. So incapacity, we have established, is when judgment and reasoning is greatly impacted by dementia. And greatly impacted means that the person cannot consider or not understand or not appreciate the impacts of their decisions. Let me give you one. Let me give you an example to help put this in. Let's pretend somebody with dementia says to their loved one, please go and withdraw $1,000 from the bank account. I would like to put $50 in the envelope for the grandkids for Christmas. They've given that instruction, but they understand that it means they have $1,000 less in their bank account, which means they have $1,000 less for their bill payment and for any of their other financial obligations. So someone who would give that instruction and appreciate that still has capacity, even though they've asked somebody else to actually physically go and do it for them. Okay, there's an appreciation, there's an understanding, and they can certainly see how it impacts their overall situation. All right. So when we talk about protection mandates, the protection mandate is a legal document that lets you name in advance one or several people to look after your well-being and manage your property if you become incapable of doing it yourself. So sometimes we hear terms like apt. The person is not apt to make decisions. Or the person is not compos mentis. Or the person doesn't have the mental faculties to make decisions. I'm not a big fan of the word apt. I'm not a big fan of saying competent. I'm not a fan of those words. I find it's not respectful language. So we often hear, oh, he's not apt. That's not something I like to say, or I will say. I will instead say the person is no longer capable of making decisions. So I know apt is a quicker way to say it, but in the language that I use, I find it can sometimes sound disrespectful. So I don't use that. But if you hear them, doesn't mean the person means disrespect. We're all saying the same thing. We're just using some different terms, which again makes it a little confusing when we talk about capacity if we're all using different terms. Okay, so a protection mandate is something that is made with a notary or with a lawyer. If you make it with a lawyer, it must be probated by the courts. So your best bet is to always make your protection mandate with a notary. I will say that in the context of dementia, you are absolutely capable of printing up a form online and signing it with 2 witnesses. I'm a little although it's legal and it's perfectly acceptable, sometimes it's questionable if the person is understanding what they're signing. So if your loved one does have a diagnosis, I would really encourage you to please go and see a notary. A notary has checks and balances to make sure that the person understands what they are signing, so it is never called into question in the future. Okay, so this legal document, in it often the language will say, if ever the day comes that I am incapable and I'm not able to manage my property or make decisions for the protection of my person, I want A, B, and C to be my mandatory. And I love that. I love it when someone has made a protection mandate because it is them telling me what they want. So really, they're driving the bus in terms of this process. Even though they're living with an incapacity, they're telling me, they're preparing this for us in advance so that we know we're respecting their wishes. And that is worth its weight in gold. I really feel like the person is telling me, Mandy, this is what I want. And I'm able to work it through with them. Because without it, then we're left to guess. And I prefer to not have to guess. Sometimes I have to. But I prefer with a protection mandate that you've told me and you've signed the document and you have made it very clear what you want. So the person you name or the people you name in your protection mandate to look after your well-being and manage your property is called a mandate. So in protection mandates, they are called a mandatory, a designated mandatory in the document. Now, I do want to talk a little bit about the spirit of protection mandates, because I do have a couple of extra minutes. I'm a little ahead of time. So the spirit of protection mandates has changed since 30, 40, 50 years. Under the old civil code, we used to call them, before 1990, we would call people who were incapable, we would call them legally les interdits. So people who were not allowed to have credit cards, manage their own bank accounts, they were not allowed to do these things. And Quebec City actually had a master list of all the people that we would open up these protective supervisions for. And you would have to call up the government and ask, is this person on the list? But we called them les interdits, which today I don't know if you share it with me, but I find that so disrespectful and such shocking language to use. And then, you know, after 1989, after 1990, when the civil code was revised and updated and modernized, well, then we started to call them mandates in anticipation of an incapacity. We also would say incapacity mandates. And that was fine. Okay, it meant that I'm preparing for the day that comes that if I should become incapable, I'm preparing for it. But really the change came about 2 years ago when the CAC modernized all protective supervisions, including homologations and mandates, when we decided to change the name to a protection mandate, which, in my opinion, is much more reflective of the spirit of the document. We want to protect the person from living prejudices under the law. We want to protect them from the difficulties that they're living because of their incapacity. We don't want to control them. We don't want to force them to do things. We want to protect them. And that's where I find we are moving forward in a much more kind, respectful, and inclusive fashion when we are talking about that. So, your loved one has dementia. They have a protection mandate that's been made. It's maybe sitting in your filing cabinet or at the bank in the safe deposit box. And then the $1 million question. When should we think about getting our loved one assessed? Right? Because we've just talked about today, we're not assessing memory. We're assessing judgment and reasoning. So, I wish I could tell you that there is a gold standard, that there is a line in the sand, that there is an exact moment that you should consider getting your loved one assessed. And I'm sorry, I've been doing this now for 10 years, and there is no such thing. And I know that that's not what anybody wants to hear. They want to know, at this point, this is when I need to get it on. Okay. I'm going to give you some background information, and today I'm going to give you some, based on my experience, when you should start considering getting your loved one assessed. Okay? So there's no definite test to determine if someone is still capable of making decisions to manage their affairs and make decisions for the person. Whenever we talk about incapacity, we talk about two different spheres. We talk about the financial sphere. Can they still manage their financial affairs? Can they manage their assets? Can they manage their property, which includes bill payment, which includes meeting with the financial advisor. And it means being able to give instructions about what needs to be done with their assets. And then for their person. So protection of person would include being able to defend themselves with the help of a lawyer, being able to vote, being able to contact the appropriate authorities if they have an issue. Let's say they use their RAM2 card, their Medicare card, and they need a new one. Would they know who to call? Would they be able to explain their needs? And for services, are they able to ask for the appropriate services for their situation? Okay, so that's when we look at the protection of person. So again, we are unique, right? We are unique individuals. Hence, there's no one test that says, are you capable or not? So instead, as social workers, we explore different aspects of the person and different elements to decide. No one aspect or element will determine if a person is still apt to make decisions. I included the word apt there, not because I love it, but because I want you to have the bells go off if you hear that term, not to disregard it if you ever hear it from another source. So we explore these different aspects. Some things that I look at when I'm considering, is somebody still capable? So when I get a call saying, Mandy, I need you to assess my loved one to homologate their mandate. Okay, we're cutting to the chase that we're homologating the mandate. But as a social worker, I'm going in there and I know for sure the person has a diagnosis because the loved one has told me by phone, but I'm not making the assumption that they're incapable. I'm going to go in with an open mind and determine. If I determine, yes, the person isn't capable, well, yes, we're going to homologate. So some things that I look at are the famous MMSE or the MOCA test. A lot of people put a lot of stock into the MMSE and into the MOCA. The MMSE and the MOCA were never developed to determine if somebody is still capable. Never. The people who made these tests will tell you that as well. They were never. They were meant to alert us if there were cognitive difficulties. That's all they were designed for. They were not designed to tell if somebody is capable. And in fact, I've seen people who score 24, 25 on these tests, and judgment is gone. Judgment has been gone a long time. And then I see people who will score a 12, a 13, a 14. Yes, there's deficits. Yes, there's memory issues. Yes, there's organizational difficulties. There's dysexecutive syndrome in there. There's all sorts of stuff going on. The judgment is still there. So looking at the MMSE or the MOCA is not the be all and end all for determining capacity. However, in my experience, when we start seeing an 18 or a 17, our antennas should perk up and say, maybe it's time to get assessed. As a social worker, I also interview family members. I need to get your feedback, okay? I need to understand how we've gotten to this point, your concerns, and I need to understand how the person's functioning. The person's in the hospital or was recently in the hospital, I might read their chart from the hospital. I will look at other specific assessments done by other health professionals. Often it's occupational therapists. There's been an OT assessment that's been done. Or there could be a neuropsychologist did an assessment, or a neurologist, or a geriatrician. And then any other relevant document. The SAAQ, for instance. If you've received a letter that your loved one's license has been suspended due to their conduct on the road, and it's suspected because it's from the dementia, I'll look over that as well. And then I interview the concerned person. So I take all of this into consideration. And I do that because it's the right thing to do. It's the fair thing to do. It's not the easiest, it's not the most convenient, but it's the right thing to do for someone who has lived a lovely life with adventures and misadventures and everything in between, to be given a fair shake when we're deciding, are they still capable of managing their affairs and protecting their person. So another thing I would say, I want to give a few more anecdotes. So I would say when you start seeing the MMSE at around an 18, that could be a time to start considering it. If the driving has become a serious issue, don't forget, when we drive, we use judgment. Driving is one of the areas of our lives where judgment and reasoning, you got to have it on all the time. If we see the person is doing, I'm not saying, someone cuts them off and they have an accident. That could happen to any of us. But when we're starting to see a lot of dents on the car and they can't explain what happened, when we start to find out that they didn't make it to their dentist appointment because they got lost, and they know the dentist's office, they've been going for years. When you're starting to say, I don't feel safe driving with this person, or this person shouldn't be driving anymore, or we're seeing frequent accidents, we're also seeing a change in their behavior on their own in that maybe they're going through stop signs because they don't realize what the stop sign is meant for anymore. Maybe speeding tickets because they're not paying attention where they're driving. That would be another time that I would say it's maybe time to get an assessment. Often also, if there's been a change in, let's say, their sleep patterns, they're not sleeping at night, they're restless at night, you see them wandering out the door, maybe not dressed appropriately, maybe in this cold weather now, I often get calls that someone went out in their pajamas and was walking the streets in the middle of the night because they've confused day and night as the dementia progresses. That's another pretty big telltale sign that we're going at. If you feel that the person was once very interested in understanding their finances. So, there's some people every month, even if you're doing it for them, they'll say, okay, I want to see my bank book. I want to see my statement. Did you pay this? Did you pay that? And all of a sudden they're not interested anymore. There's no interest at all. They're not able to follow when you talk to them about their budget. They're not able to understand that when you're informing them about their finances, there's just a complete cutoff. And when we're at the point that the person has to be supervised at all times, when you're starting to see these types of behaviors, if you're checking off a lot of these boxes, not all, but a lot of them, it's time to start considering getting your loved one assessed. Okay. Before we get into what is homologation, I just want to ask, in the Q&A bar, are there questions? Q&A. Let me pull that up.
Okay.
Yes.
One of the, yeah, you see it?
Yeah, I see it. So you
Okay,
may,
good.
however, just to confirm, will you share the presentation to us afterwards? Absolutely. It was made for you. Absolutely. Is the protection mandate available from the government website adequate, or is a notary necessary? The protection mandate that they currently have on the government website, you have to make sure it was updated since November 1st, 2022, because there was changes to the law. So I'm unfortunately seeing quite a few that people downloaded off of just different websites here in Quebec that don't have everything that we need since November 1st, 2022. So if you're downloading anything, please make sure it's been made since November 1st, 2022. And the best place to check that would be the Curateur Public du Québec website. There is an English section. No, then the next one, it's a protection mandate, the same as the living will. People often call it that. In Quebec, we don't use the word living will. This is something that we would use in the common law system, whereas Quebec were under the Napoleonic Code. Do people use that phrase? Absolutely. Absolutely. And I know what they're saying. Is there a validated questionnaire tool available to assess incapacity? No, there's not. That's why it's based on all the assessments that are being done by neuropsychologists and everything that I just explained. Okay, I think there was one more. Can you put that website in the chat? I can try. I'm sorry. Let me see that.
You know what, Mandy, may I suggest that maybe these resources you can send us to us by email and then we'll send it to the,
You know what? When you send out the
yeah,
presentation, maybe we can put that.
exactly.
Okay, I think that
Yeah,
that's fair. That's wonderful. Thank you. I hope that that's
no.
okay for the person who asked the question as well. All right. So we've looked at the questions, and now I want to jump into what is homologation. So anything that we can make complicated in Quebec, we do. Homologation is a very fancy word that means to agree or to make official. Okay, that's all it means. So engineers are actually quite familiar with this process of homologation because engineers will homologate products. They will be given specs of a certain product and they will check, are these specs and does this product actually do what it says? And the product gets homologated by an engineer. All right. So homologation comes from the Greek word to agree. All right. And when we homologate a protection mandate, we are giving a person legal authority to make decisions and legally represent another person. So I want to be very clear here. People will often call me because they've either waited too long or they've hit a proverbial wall. And what do I mean by that? Even married couples, you do not necessarily, just because you're married or you're in a de facto union, often known as common law, think that they have legal authority to be managing the affairs of their loved one, of their spouse. And this is not true. You can work in concert with your spouse when they are capable of making decisions. You can follow their instructions. However, you cannot be making decisions completely for them if dementia has advanced to a point that they cannot appreciate their decisions. You just simply can't. You do not have the legal authorization to do it simply because you're married or simply because you have a power of attorney document. So this is another piece that people get confused with. They think that by having a power of attorney, they can manage the person's affairs forever, till the end. Now, for most people, that is a possibility. But as soon as dementia has progressed to the point that the person is no longer working in concert with you, no longer understands what you're doing on their behalf, the power of attorney is not good anymore. And you can find yourself in a very murky, gray legal zone. So common reasons why I see people in a panic because they've waited too long is their loved one is transitioning out of the home and they're going to a care environment. So often we call that a residence or to a CHSLD, but they're going and they're going to be receiving care outside of the home. And let's say there's fees involved and they call up the financial planner and they say, well, I'd like to draw down more from our investments to pay for his care, my husband's care. Let's make it easy to say it's the wife calling for her husband. Well, if Monsieur cannot give permission for that, he cannot identify himself to the financial planner to say, yes, this is what I want. They can't do it because now you are administering the person's assets because you're not working in concert. Let's pretend the husband was well and the wife called up and said, we're going to need to draw down another $2,000 per month to pay for his care because we're having care come in. Let's say it was simply a physical issue and the financial planner said, can you put Monsieur on the phone? And he said, Monsieur, your name, blah, 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 your date of birth, blah, blah. Are you okay with me giving you $2,000 more per month out of your investments? You understand it means that you will have less in your investments. And the person says, yes, I understand. I need the extra money. It's fine. You're working in concert with each other. But when you're actually administering it, that's a different ball of wax, and you will not have legal authority to do that. So I often get calls for that. And it has to be done very timely because we have to pay for the care. I mean, there's no ands and buts about it. Another time is when people need to relocate, but they're refusing to go to a care environment. Homologating the mandate for all intents and purposes, can be helpful in having the legal authority to be making decisions. And then the third scenario is when people leave the home. So it can happen that people leave the home and the home needs to be sold to pay for the care. So not everybody has investments that they can draw down from. But maybe they have a home that, a lot of us are using our home for the proceeds of our home for a rainy day. And when that rainy day comes, you cannot, if a person is not capable as defined by the civil code, they cannot pass at the notary for the transaction. So that can become quite difficult to manage because it takes time to homologate a matter. And we end up sometimes losing the seller. But look, I'm not hysterical. I'm not a dramatic person. I'm just giving people food for thought of when I tend to see people who are really, really in a tight spot, in a jam. All right. So we've established that the POA is not the be all and end all either in terms of administration. When your loved one is very much in the throes of dementia, the POA is simply not enough. So when we homologate a mandate, we validate three main elements. One, the person is no longer able to make decisions to manage their affairs and for their person. That's what I start with. I start with a conversation, an interview with the person, all those great things I told you that I read and go through to determine, is this person capable? So for this exercise, we're going to say, no, they're not. I've determined they're not capable. Well, then I need to look at the mandate because now we need a third party. We need another person to make decisions for them. And then the third thing that we're looking at when we're homologating the mandate is the chosen mandatory or mandataries, if there's more than one, are they able to take the role and are they fit for the role? Sometimes mandates were made 10, 12 years ago. Sometimes the person, one of the people that they've named in it has passed away. That person can't take the role. Or maybe the person that was named it has moved to Australia and cares about their loved one, but is not themselves in any position to be assuming the role. So I'm checking to see if those people are available, are fit, are capable themselves. We have to remember that when we homologate a mandate, it is the removal of rights. We are removing somebody's right to make decisions. And it means that the mandatory has the final say, makes the final decision. It's not something that we should ever do for fun, for convenience. It's because it's necessary. And it's very confronting for loved ones, for caregivers, when they realize that their loved one has reached this point in their illness and that they can no longer make decisions and that their right to make decisions has to be removed. So we have to do that with kindness and compassion, always, because the person did not choose this situation. They did not choose to have dementia. This is not what they had planned. So we have to be very careful with that. Now, although at the end of the day, we are removing rights, and it's hard. It's something that's very difficult to accept. There's often a lot of grieving that will happen during this process. We have to remember the spirit of the protection mandate. It's to protect them, not to punish them, not to control them, not to hurt them. It's to protect them. So when we try and we have to keep that in our perspective. Okay. So I know I discussed the POA, and that's often a part where people have a lot of questions. So I'm just going to go to the Q&A bar. I want to have a look-see. Website in the chat. Yeah, we did that. Does the financial manager of my husband's bank have the legal right to demand a copy of his mandate? They have a legal right to see if your POA is still valid. They have a legal right that if your husband goes into the bank and cannot identify himself, or they feel he doesn't have capacity, they can ask to see your POA, and they have a legal right to see your mandate. Your mandate really doesn't mean anything until it's homologated. They have a legal right because part of their role is to protect their client. and in this case, that is your husband, they have every right to ask that. Yes, I like this question. This is from Richard. Are there notaries that specialize in mandates and homologation related to dementia and Alzheimer's? If so, how do we find them? I really like this question. Okay. Okay, so yes, so notaries, great. This is a great question. So not all notaries do homologations. Who would have thought, right? Who would have thought? So yes, there are some that specialize in this. They've done an extra course to be able to do it, an extra certificate. And this is all they do. So these tend to be notaries who specialize in what we call family law. So they don't do as many property transactions like for real estate and real estate sales and so forth. And there's about 3 or 4 of them here in the West Island who specialize in it. And when I send my slides to AGI and I send the name of the website, I'm going to send the name of the ladies. I'm sorry, they're ladies, all ladies. Sorry. When I find the man, I will let you know. Mandy, can you please speak directly to the screen and not to the side as now, because I will hear you better. Thank you so much. Okay, I'll try my best. Is it still advisable to homologate this is Kate Coulter. Is it still advisable to homologate a mandate if they have no property or investments? Sometimes we can just ask for third-party administration. Sometimes we can ask that, but that can get tricky because there's some areas that here we're thinking about the financial piece. We also have to think about the protection of person piece. Okay, so that would be something that we would have to explore on a case-to-case basis. If someone is diagnosed with mild cognitive impairment but is very high functioning, is this the time to prepare a mandate? Yes, this is the time to prepare it. Likely the notary will ask you, likely the notary will ask for a note from their doctor saying that the diagnosis is MCI and that the person is capable of signing the document. But yes, absolutely, this is the time because mild cognitive impairment can remain MCI forever, or it could eventually evolve into dementia. Is the POA the same as a mandate? No, a POA is a, oh God, I just forgot it. POA, no, a mandate is a protection mandate. This is something different than the POA. A POA is when the person is compos mentis or capable and you are executing their instructions. A mandate is a completely separate document. Okay. Okay, tutorship. The tutorship piece. So please explain where tutorship is done. There's a few power of attorney is a POA, power of attorney. So the tutorship piece, I will have to explain it in a nutshell because it's actually, so I see that Barb, okay, please explain what tutorship. It's actually a presentation on its own, tutorships, but in a nutshell, nutshell, like the most basic of explanations, is a tutorship happens when a person does not have a mandate. Or they have a mandate and all the people they have named as mandatory are not available to us, and we have to go with tutorship. Or, and here comes the big one, if nobody agrees that the person you have named as mandatory is an appropriate person, i.e. there's been financial fraud, or there's been neglect, or lack of care given. But this is a presentation on its own, but tutorship is really when the person never made a mandate. Let's leave it at that, or our mandataries are not available to us. Can we have 2 mandatees on HM? I'm thinking it's homologation, daughter and son. Absolutely. Absolutely. Oh, isn't that kind? We have a Tamara. We have a notary here in the group. And this is wonderful. You can always find a notary and filter with the practice of the notary. And in fact, this tool that she's put up, you can filter by region, filter by language, filter by gender. It's a really nice tool that they have from the Chambre des Notaires. So thank you for that, Tamara. Yes, the mandate must be homologated for the home to be sold unless you go in front of the courts. I don't want to take myself as a notary. This is tricky. So Catherine Lloyd, this is a very, very tricky one. Very tricky. Because I've had clients that when the house was put up for sale, they consented, they were okay with it. By the time it was sold, when they went to see the notary did not let the transaction go through, because even though they were consenting, they didn't really understand what they were consenting to. Okay. Okay. But that one we could discuss, Catherine, a little bit more. You can have now, poor judgment is not the absence of judgment. If judgment is gone, if the person cannot give me the address of the property that they want to sell, they cannot give me the approximate value of the house that they want to sell, they cannot fully consent to it, then, because I do these assessments for notaries sometimes when they're not sure, then it's very difficult to have that transaction go through. Okay. What are the concerns if family waits too long and a person now has advanced dementia and only has a POA? Well, then you have no choice but to have a tutorship. And with a tutorship, we have to name the tutor. We have to name a family or tutorship council, and the public curator oversees all of your administration. So tutorship seems to be a subcategory that's coming out today. And maybe in the future, AGI, maybe we could just talk about that.
We'll definitely do.
Thank you. Thank you. So yeah, so I would say it's honestly, I really, really prefer documents that have been notarized. Again, you can take it off the government website and do it as you wish, but I always find that they still need to be probated by the courts. That's why I always really like the ones that are done by notaries. We know that they've done their due diligence to make sure the person understands what they're signing at the time. So it's not called into question in the same way as if you take it off the website. Okay, now, so what? Why do we homologate a mandate? When a person is no longer to make decisions to manage their affairs and for their person, to protect the person living with dementia from living prejudices under the law. Okay, someone with advancing dementia, not uncommon if they're living alone and people don't realize they haven't been paying their bill. Come March, their hydro gets cut off because the bill hasn't been paid. They're not paying the bill because they don't want to, because they've forgotten to, or they have forgotten the concept of it. Okay. I mean, there's always this, and this is the one that breaks my heart always, to protect a loved one from fraud or ill-intentioned individuals. We've all gotten calls from the CRA, right? We've all been told that there's a prince who wants to send us some money. Many of us open up our inbox or answer our phone and, oh my goodness gracious, who wants what? And you know, when judgment and reasoning is diminishing, we're much more vulnerable to these types of people. I don't even want to call them people, but these ill-intentioned individuals. We're much more vulnerable. It's much harder to use that judgment and reasoning, or even our memory to say, oh geez, I heard about this on the news the other night. No, and close the phone, right? And then the final reason, but not the least important reason, is to ensure a loved one can be well cared for and are receiving the appropriate service. Okay, so we are going to talk a little bit about how do we homologate mandates. I really hope I have not confused you all anymore. But anyway, how? I prefer to do a little chart, a little table, a little visual here. So the first step is you would meet with a notary and you would sign a solemn declaration that your intention is to homologate a mandate. Next step, you would get the medical evaluation done by a doctor to look at the medical fees, and the psychosocial assessment done by someone like me, a social worker. These two steps are the exact same whether you're going to be doing like a tutorship or you're going to, getting a medical evaluation and a psychosocial is the same for a tutorship as it is for homologating a mandate. Okay, just put that out there. Then step 3, the notary takes care of preparing the file for the courts. They check many things, and I'm not a notary, but just to give you an idea, They check the register of la Chambre des Notaires, they check the Barreau du Québec to see if maybe the person made an updated mandate that we're not aware of. Could happen. We get surprises sometimes. And then they send the application down to the courthouse and they take care of the legal piece. And then the application is deposited to the court and a court clerk is assigned to the file. So it's a court clerk who renders the judgment. Okay, so that's step 5. And they have their own different steps to do inside that process, which I don't want to get into too much because I think we've already covered quite a bit. But you get a judgment from the courts. You'll have, if it's done here in Montreal, you'll have a file number 500-12- whatever. And that is your judgment to say the courts have deemed the person incapable. The mandate has been homologated. You are now this person's legal representative. One thing that I do have to say, a lot of people are nervous that their loved one is going to have to go to court and appear in front of a judge. This is often something that I hear. And I have to tell you, I find that very scary myself. But that's not what has to happen. It's a special clerk who takes care of the file and will meet your loved one through Microsoft Teams and just to attest to their identity. And if they are able to give an opinion, give their opinion and answer some basic questions from the special clerk. And to date, I've done many of them with clients. It's not scary. They're not rude. They're not harsh. They're actually quite sympathetic, the special clerks. And then my last visual, which I always hope is my most powerful visual. Okay? When we are talking about homologating a protection mandate, the person in need of protection is in the middle. And you see how we are all on the outside, the mandatory loved ones, the social worker, the notary, the medical doctor. It's like we've all got our arms around each other's shoulders. We're protecting this person. We are creating a barrier. We are trying to make sure, one, that they are always in the middle of everything that we do. They are our driving factor. They are our client. They are the person that the well-being of is the most important to us at that point when we're doing this process. And then we have the rest of us on the outside working together for them. Okay? So, questions and comments. I'm going to go to the Q&A bar. There's been 2 fresh questions since I went through. Where can we find social workers, public preferably, who can complete the paperwork for homologating a mandate? Okay, so public social workers, you can contact your CLSC and ask to be put on the list. It's about 18 months for the social worker to do it. Many CLSCs make it their lowest priority. So if you're not already receiving home care services, you have to open a file and get assessed for the home care services, which can cause additional delays. And then if the only reason is to homologate, they will tell you from the point that the file is actually open, it's 18 months before the social worker will do the assessment. Okay? That's the only public social workers. You have to have a license through the Order of Social Workers, and you have to be specifically trained to do it. So many of the CLSCs now are not hiring social workers, they're hiring therapeutic activity specialists. So they're not in the order and they can't do it. So I've been told that some of the CLSCs, the wait time is now 24 months. Okay. Approximately how long does it take to homologate a mandate? There's so many variables. I have to be very honest. There's so many variables. Just like if you go with a public social worker, you're looking at 2+ years, because then you have the court time, then you have the notary time, you have the court time. You also have the time it takes to complete the assessment, versus if you go privately with someone like me, which is much faster. It also depends on how long it takes the doctor to fill in the paperwork. So the doctor has to do a medical assessment. Some doctors are really good with paperwork, you all know, and some doctors not so good. Okay, so that can be another variable. We have Maureen, is this presentation going to be archived?
Yes, we will be as soon as this is currently being recorded. So as soon as we have it edited and everything, we will be sending it to you, or you should be getting an email from us that it's ready for you to view. So yes,
And I will send all that additional information that I
yes,
have.
yes, please.
And then we have Tracy. Thank you, Mandy. You're an excellent speaker and wonderful for sharing your knowledge on this topic. Well, that is really kind. Thank you. Thank you. That warms my heart. Thank you so much. And Dorothy, can my family doctor do the first step? So if the first step is the medical form, yes. Any MD here in Quebec is qualified to fill in the medical assessment. Some family doctors are more reluctant, and if there's a neurologist or a geriatrician in the file, they sometimes bounce that back to them. But many times it's the family doctor who is providing the medical in this particular case.
Yes.
So that answers all the questions that were in the Q&A. I'm sorry if I rushed through some of the answers. It's not my intention. It's just I wanted to make sure that we got, through it all. But I will provide my email address as when I send out all the additional information I've promised. And if you have something that's very particular to you or to your situation, you're welcome to email me, and I'm happy to have a call with you to go over some of the particularities.
Mandy, thank you very much for taking the time and the effort and your eloquence and expertise, sharing it to our caregivers and to the people who support AGI. This is very, very, even for me, again, to learn more about it and to remind me of other things so that I could properly support the families as well. Again, thank you very much. And for all of you who need to contact AGI, please feel free to give us a call, 514-485-7233, or email us at info@agiteam.org. And we will be as soon as we have, as I've said, as soon as we have the video ready, we will send a reminder to you that it is ready for access. Oh, hold on, there is. If we have time, there's one more. Suzanne says thank you again. So
Thank you.
yeah, again, Mandy, thank you very much. More power. This is not the last time you're going to hear from us. So
Thank you. I wish you all a wonderful day. I'm available to help you. And listen, keep doing your stuff because you're all very wonderful. Thank you.
Thank you. Bye-bye. Take care.
Bye-bye.